Now, about 13 tenants claiming to be residents of the Pangani estate, 9 of whom were verified to be bona fide tenants, and 3 of whom were not traced in terms of the records by the Nairobi City County government, had filed a case in the High Court trying to stop the regeneration project that has commenced. Now, the hearing of the case was scheduled for today, and we had been given this date because the plaintiffs, the claimants, had said that indeed this was an urgent application, but they did not show up, in consequence of which their application for injunction was dismissed, and therefore there is now nothing blocking the project from taking off. The urban renewal project did not start yesterday. It is not something that the county government of the city of Nairobi woke up to. There has been intense consultations engaged between the tenants and the Nairobi City County government. In particular, the housing department has taken every precaution that is envisaged in such a project to ensure that the mandatory provisions of the law, especially surrounding public participation and consultations between the government and affected parties, are adhered to. And the county subscribes in every manner possible to adhering to those principles of public participation. So when they had filed this case, their key plank in trying to stop the project from going on was the allegation that they were not consulted and that their objections were not taken into account, that they will suffer prejudice, they have nowhere else to go, and this is a place that they have lived on, some of them for 50 years, without proof though. They do not prove or tender any evidence before the court that they have lived in Pangani estate for that period of time. Be that as it may, the court had ruled that they should come and articulate their case, which they had failed to do. The urban renewal project is a project in tandem with the national government agenda the four-spoked agenda, and it must be borne in mind that the population of the Nairobi City County has expanded over time, and with that, the constricted housing has in turn posed serious challenges, especially given the UN targets on housing that is decent, that is affordable, and that is not going to lead to the creation of slums. And therefore, the relocation of these tenants was geared towards providing ground for the expansion of the housing capacity within Nairobi City County government. And if you compare 48 families to the 1,500 that is likely to be accommodated in the same area, you would immediately appreciate that the county government is going out of its way to meet the target and the obligation to ensure that adequate housing that is affordable to the residents of Nairobi City County is availed. And therefore, the fact that this injunction has been now removed as a blockade from this project is something to be happy about, and we hope that the project can go on unhindered, to the intent that the Nairobi City residents then can find affordable housing, at least with this project. I believe that if these tenants had found objection early enough, they should have come to court before even the groundbreaking process had been planned. But they came too late, they were not prepared, and in my view, they were not even ready to prosecute the case. I think in our country we have come to a point that we must make a deliberate choice whether we should entertain such frivolous, and I say that with tremendous respect, not intending to demean or otherwise degrade the claim by the plaintiffs. such claims as would hinder the wider, larger public interest. Of course, we must align all those interests in tandem with the policies and the development objects that the county has in mind. We cannot close our eyes to the fact that with the burgeoning, with the expanding population comes the expectation that the county is going to render services commensurate with the taxes, the levies, the rates that are collected. But if we find someone standing in the way of the fulfillment of that expectation, indeed a legitimate expectation on the part of the Nairobi residents, then we have to question. And that is why the Nairobi City County government said that in recognition of the right to access justice, we ventilate this case in court, and we have so done. And we table the material before the court, showing that each of these tenants had been consulted. Each of these tenants had been given an opportunity to articulate their views, to articulate their objections, if any, to then express their desired manner of dealing with this issue of relocation, which they did, which they did not challenge at that stage, which we believe then afforded them a platform, an opportunity, a springboard, as it were, then to challenge whatever it is that they saw did not meet their expectation. That having never happened, then obviously the project needed to roll out. And in sum total, the urban renewal project will affect other estates. For instance, Jivanji, Barchalas estate, Nungara estate. And equally, in the same fashion, there has been public participation way back from 2015, 2016, 2017, all through up to date. So none of those tenants that are resident in those estates can allege that they have not been consulted or informed of the development project that is about to be embarked upon to expand the housing and avail what is modern, efficient, and affordable. The Nairobi City County government, in embarking on urban renewal, also takes into cognizance the 4 agendas that the President, His Excellency the President, has articulated, and it is important to the Nairobi residents to support this project of urban renewal, so that the structures that were erected to cater for the housing during the colonial period are upgraded. And those structures, as we all admit to date, are dilapidated. They can only afford a minute number of residents the accommodation that would be commensurate with the needs of the time that those structures were erected. And times having changed, demands having increased in terms of housing, and challenges having arisen in terms of spatial availability of such housing, then we must have innovative ways of availing affordable housing to a larger swath, a larger section, a larger number of Nairobi residents with the changed times. This is the sole object of the urban renewal project. It is not something that the Nairobi City County is embarking upon in order to divest proprietors of that which vests in them. No. There is a fundamental distinction between relocation and eviction, and this is something that those who had filed the case in the High Court had totally missed out. And some of them, you cannot blame them entirely because they are nostalgic. They have lived in this estate for a long period of time, and so they would feel the detachment that comes with relocation. But you cannot embark on the project without relocation, so these people have to relocate. And they will be given first priority. They have been given 600,000, each of them, in order to facilitate and enable them relocate. And so they are not being evicted as erroneously created by them in the eye of the public. So the county government is handling this with dignity, with decorum, and professional standards that are expected of it in a situation like this. Thank you. Sawa.